In a scene that veteran court watchers are already calling unprecedented, the legal team defending former President Donald Trump was physically removed from a federal courtroom after what witnesses describe as one of the most explosive attorney meltdowns ever seen in a high profile trial. Federal marshals escorted licensed defense lawyers out of the courtroom as one of them shouted accusations of a kangaroo court while the presiding judge openly threatened referrals to state bar authorities. This was not just another heated exchange in Trump's long legal saga. It was a complete professional collapse involving sworn officers of the court risking contempt charges, bar discipline, and even potential criminal liability. When trained attorneys, people who passed the bar and pledged candid to the tribunal, lose control to the point that marshals physically remove them, it signals that something extraordinary has gone wrong. For weeks, Trump's defense team had worked to project discipline and credibility. Their strategy hinged on portraying document retention issues as inadvertent. Inciting Trump relied on legal advice and framing the prosecution as politically motivated overreach. According to Politico's December 10th coverage, the defense had successfully injected doubt into portions of the government's timeline, forcing prosecution witnesses to concede ambiguities in email chains and document handling. Some legal analysts even suggested Trump had carved out a plausible path toward reasonable doubt on certain charges. That fragile equilibrium shattered in minutes. For days, prosecutors had methodically built toward a pivotal moment. They laid foundations through testimony and document retention policies, mapped timelines with phone records, and constructed a narrative pointing toward intentional abstraction rather than oversight. On the morning of December 10th, prosecutors informed the court they intended to introduce a newly authenticated email, part of a larger document production not yet shown to the jury. The moment prosecutors announced one additional piece of evidence, the defense began objecting before even reviewing it. A telltale sign, courtroom observers noted that something was about to erupt. Multiple reporters from CBS, CNN, and the Associated Press described how the prosecution simultaneously handed copies of the email to the judge, jury, and the defense table. The email dated August 2022 fell squarely within the period when Trump's attorneys were negotiating with the Justice Department over the return of classified materials. Within seconds of reading it, the lead defense attorney, identified in reports as Trump's primary trial counsel, stood and demanded an immediate sidebar. The judge agreed, and counsel approached the bench. What should have been a quiet conference quickly unraveled. According to CNN's legal correspondent, Trump's attorney resident raised his voice almost immediately, accusing prosecutors of fabricating evidence and demanding an instant mistrial. The judge warned him to lower his voice. He did not. Instead, he escalated. The judge called a recess and had the jury removed. Once proceedings resumed on the record, The meltdown became total. Speaking directly into the courtroom microphone, the lead defense counsel accused prosecutors of withholding exculpatory evidence, manufacturing documents, and committing what he claimed amounted to criminal fraud on the court. The judge asked him to clarify precisely what he was alleging. That question proved fatal. The attorney asserted unequivocally that his team had conducted a thorough review of all emails from the relevant period and that the email just introduced by prosecutors did not exist in any prior production. He stated they had never seen it before. The prosecutor then calmly dismantled that claim. She informed the court that the email had been produced to the defense in September as part of the third document production, clearly listed in the index as item 4732. More devastating still, she revealed that the defense itself had cited the same email thread in a pre-trial motion, omitting only the most damaging portion. She handed the judge a copy of the defense's own filing with the referenced email highlighted. The courtroom went silent. Reporters described the atmosphere as electric. Trump's attorney reportedly turned bright red, but instead of correcting the record or conferring with his team, he doubled down, accusing the prosecutor of lying and claiming the email must have been altered after production. The judge asked him directly whether he was accusing federal prosecutors of fabricating evidence. Yes, he replied. Absolutely. At that moment, the second chair defense attorney attempted to pull him back, tugging at his sleeve. The lead counsel brushed him off and continued, declaring the prosecution's conduct worse than Watergate and suggesting the judge herself was complicit if she allowed the evidence that was the breaking point. In a voice described by reporters as icy but controlled, the judge informed Trump's attorney that he was now in contempt of court and ordered him to sit down immediately or be removed. He refused, stating he would not be silenced and claiming he was willing to go to jail to protect his client's constitutional rights. The judge turned to the marshals and issued a single command: remove him. As marshals approached, the second attorney stood and began shouting that the removal violated Trump's Sixth Amendment right to counsel and proved the trial was rigged. The judge pointed it at him and said, him too. Both attorneys were escorted out as one shouted that the court was a kangaroo court and that the truth would come out. A junior attorney remained at the defense table, visibly stunned. Legal observers immediately noted the gravity of what had occurred. This was not passion, it was a catastrophic breach of professional duty. The pattern is familiar. Rudy Giuliani, once celebrated as America's mayor, lost his law licenses in New York and DC and now faces bankruptcy after defamation judgments stemming from false election fraud claims. Sidney Powell went from respected federal prosecutor to a symbol of conspiracy driven litigation, facing criminal charges and civil liability. Jenny Lee pleaded guilty in Georgia, admitted to making false statements, and was censured by the Colorado bar. John Eastman now faces disbarment and criminal exposure after advancing legal theories widely dismissed as baseless. Now, Trump's current trial attorneys appear to be joining that list. The immediate cause of their removal was straightforward. They made a factual representation to the court that was demonstrably false and refused to retract it was when confronted with proof. Legal ethics experts emphasize that candor to the tribunal is non-negotiable. Once crossed, removal becomes inevitable. The judge gave multiple of ramps, a chance to clarify, a chance to apologize, a direct order to sit down. Each was rejected, with both lead attorneys removed. Trump now faces a complex federal trial with only a junior lawyer at counsel table, someone unprepared to assume lead responsibility mid trial. Asking for continuance would expose the jury to the reality that the defense imploded. Proceeding without experienced counsel leaves Trump severely undermanned. Legal analysts warn the damage is likely irreversible. Jurors tend to interpret such behavior as desperation, a sign that the defense cannot confront the evidence. The consequences extended beyond this courtroom. Bar complaints are almost certain. Criminal contempt proceedings are possible, and the pool of qualified attorneys willing to represent Trump continues to shrink as each episode demonstrates the professional risks involved. This was not just a bad day in court, it was a collapse of professional standards unfolding in real time before a jury. And when lawyers would rather be dragged out than face the evidence, the message to jurors is unmistakable. Unmistakable. The next phase will determine whether accountability follows. If it does not, the precedent would be chilling. That courtroom rules bend for powerful clients. For now, the fallout is seismic. Trump's defense is crippled. His attorneys face potential career ending consequences, and the legal community is left watching one of the most extraordinary courtroom implosions in modern American history. The stakes have never been higher.